Alrighty, this is Diesel We the People News. Alright, never look straight forward, always look around you, be able to protect yourself by any means necessary. Okay? Be armed with knowledge. Quit going by hearsay. Do your own research. Verify. Double check everything. Okay? The reason why I like this was the Justice Revolution, right? He thinks outside the box, which is what I like doing. I'm all for people thinking outside the box. And he's going to be talking about this thing called voir dire. Okay, this is what lawyers do to get rid of uh, certain jury members they don't want in there. Okay, for whatever reason. All right, and they tell the judge, we don't want this, we don't want this, and we don't want this. Well, that's what they're doing. So, but him thinking outside the box, who says we cannot use voir dire against the magistrate or judges and challenge jurisdiction that way? Right? I had never seen it in any type of codes that I could recognize that we can't do it. So if it's not there, then it resides on the people, and the courts must reside on the people. This is the reason why tax laws are so private property tax, right? There's no law saying you have to register your property. Okay? So quit registering your property, by people, and get that tax assessor on your ass and say that you volunteered to pay taxes. That's the reason why it's not a debt, because they call it a volunteering tax. And you're going to be getting some type of privilege. Okay? Don't know what the privilege is, but you're supposed to be getting some type of privilege by your volunteering tax. And if you don't do it, well, you basically broke some type of contract that you implied to consent to, and they get to take your property. All right, I digress.
Last week I was talking about the report I was writing up. You guys remember that, about that lawsuit for my buddy Mike Brown?
Yes.
Right. So I got my report done. I want to share that with you guys. I'm going to share my screen. And I want to go through this because I feel like it's really important to go through. So let me see here. There we go. Okay, so this is the report, or the objection, I should say, to the magistrate's report and recommendation. Just a quick review. You guys remember, or maybe you don't, but if you do, when you file a federal district court case, chances are you're going to be assigned a magistrate judge. That's really high. Now, they will send you some paperwork asking you to allow the magistrate to handle your entire case from start to forward. Do not sign that paperwork. I cannot stress that more. These magistrate judges, for lack of a better term, are the minor league judges. They're the judges who are trying to get into the system, but they absolutely are not. The information I'm seeing from them is so far off in left field. It'll just make your mind. It'll make your head spin. So,
okay, so we're going to stop there right now, right? I'm not attorney, not giving legal advice. Okay, educational purpose only. It's my opinion. Okay, but when you put magistrate and Microsoft, all right, and put your red line in there, it does not recognize magistrate. Why? Because it's not part of the judicial branch. Okay, it's administrative. We got to recognize this. So what this magistrate wants to do is put you administrative and not your rights. Okay, they don't want you to see an actual judge. They want you to keep everything into administrative action, which we talked about in a couple of other videos before this, right? They're finally getting some restraint, but in general, that's what a magistrate is. Okay, it's just overpriced clerk of the court. Okay, he's just gonna go through there and see if it should deny or whatever, and then hand it to the higher courts, gives a recommendation. The higher court judge is going to say, all right, well, I'll take it under advisement, kind of skims through it, and it says, okay, I'm going to go ahead and accept your magistrate unlawfulness, and we're not going to let him jump up here. Us judges don't want to mess with you little peons. Okay, we don't like our subjects up here. We don't want them educated.
Anyway, so what we did is I took the report that she issued. So what happens is, you file your lawsuit, the other side files a motion to dismiss or some other frivolous document. They refer that over to the magistrate judge. The magistrate judge goes through it. They go through your
P.S. Yes, he denied it, but what are they doing? They're forcing it in there. Okay, a couple of my paperworks, right? I'm one of the people, but they forced me into the corporate person. So I got to come back and combat that and all that. Hey, what gave you the authority to put me, a man, one of the people, into this corporate person? And how did I become a creature of the state? And where's the citizen nexus attaches this transfer?
complaint, and then they issue their report and recommendation as to what the court should do with your complaint. For the long story short, this magistrate judge, here's her name right here, Cecilia M. Romero, and I don't care. She's a public judge. Her name can be out there. Cecilia M. Romero. She issued a report recommending.
Now, that being said, recognize the difference, all right? He said judge, but she's still a magistrate, okay? So, when you go get a ticket and you go in there and call him a judge, he's not actually a judge. He's a magistrate. And I think we need to kind of read our words when we walk in the courtroom and call him what his name is, a magistrate.
That they grant the defendant's motion to dismiss. So I came back and threw it back in her face, quite literally. So the first thing I did was I'm challenging the jurisdiction of Cecilia Romero. I'm doing that through a voir dire. Voir dire. That is a Latin term. Really what you're doing is you're challenging the validity of this individual. It's typically, this process here is what is done to challenge the validity of a juror. So when you're selecting jurors, you're like, hey, I've got a voir dire of this judge, and I'm not even sure I'm pronouncing that right, but I think I am. Of this juror, I don't believe that they're valid to sit as a juror. You can use the same approach for anybody that is on your case. So I put the court on notice that this is a jurisdictional challenge. This court has noticed that Romero is required to take an oath to uphold the Constitution of the United States and maintain a copy of that oath at her place of service for inspection. Absent this proof, Romero is neither a
All right. Now, inspection 5 USC 3 2906. She needs that oath of office. However, if you're going to do this, y'all, there's several oaths they need to take. And one of the most important oath of office, and I said in past videos, and you got new people, right, is Article 6 USC 4, Title 4, Section 101. Okay, they must fill that out. And matter of fact, by the second act of Congress, when they transferred it into the USC, right, it says everybody. Okay, so even administrative that's ordering you to do certain things, they're supposed to have the CPS employees, they're supposed to have that oath of office. Because of our ignorance of this, right, they've been overriding our rights. And we're accepting their authority under illusion, false pretense, and under duress. And ignorant of the law. All right? And they say it's no excuse.
Nor de jure officer of this court, requiring that this court disregard all of the papers filed by Romero while she was impersonating a federal officer. Okay? So that's the first thing I did. Thoughts on that first part?
Okay, so when he did the impersonating, let's be clear about this, right? Uh, he could not see the oath of office. They're supposed to have it on hand. And when you call them out, I want to see your oath of office. Every place they're supposed to conduct business, even if it's a magistrate judge or and a regular judge, right? If you have a judge is traveling from like uh, Odessa to Midland, they got to have that oath of office in that room beside them and in that clerk's office. And that's all the oaths. You got, I can't even remember how many oaths it is. There's about 4 or 5 oaths of office they actually have to take.
So far, you guys.
Jaw dropping. I can't wait to see where it goes from here.
Yeah, well, just wait.
I know.
So
Okay.
this is submitted.
Actually,
You can use the same approach for anybody that is on your case. So I put the court on notice that this is a jurisdictional challenge. This court has noticed that Romero is required to take an oath to uphold the Constitution of the United States and maintain a copy of that oath at her place of service for inspection. Absent this proof, Romero is neither a de facto nor a de jure officer of this court, requiring that this court disregard all of the papers filed by Romero while she was impersonating a federal officer. Okay? So that's the first thing I did. Thoughts on that first part so far, you guys?
Jaw dropping. I can't wait to see where it goes from here.
Yeah, well, just wait.
I know.
So
Okay.
this is submitted already.
Yes, this was filed with the court. So Mike submitted this to the court earlier, I want to say earlier this week or late last week, one of the two.
Okay, and I got your pronunciation. It's voir dire, like deer.
Voyeur deer. Okay.
Voir dire, like deer in the headlights.
Okay, voyeur deer. Got it. Voyeur deer. All right, so one of the things that I really wanted to harp on, because I this is now the the fourth case that this judge, magistrate judge, has been involved with, Romero. And so I harp on the fact that even if she is a bona fide officer of this court, she cannot show this court that she's complicit with her presumed duty to do equal justice under law by showing this court that she has ever recommended that a pro se litigant's case should go forward. Because in every single case that I've submitted to the court, every single time she's come back recommending that the motion to be dismissed be granted. Every single time. Every single time. So now the second thing here is I really harp on the grounds for objection, because when you guys see what's happened with this case, why I'm saying our ground is fraud on the court. Okay? Fraud on the court is defined as a fraud perpetrated by officers of the court so that the judicial machinery cannot perform in the usual manner its impartial task of adjudging cases that are presented for adjudication. All right? You'll see why I'm talking about this. This first one hits on it right here. So, and I apologize, for those of you who are watching, you guys can read this, but there are a lot of people that listen to us, so that's why I'm reading this for those who are listening. So my second contention is that her report is erroneous from the beginning to end. And here's where it starts. The defendant's motion to dismiss under Rule 12b-6, which is the one motion to dismiss for failure to state a claim, must be converted to a summary judgment motion, that's Rule 56, for summary judgment. And here's why. I said that this magistrate judge has misapprehended and misapplied the court's taking of judicial notice of exhibits filed with the defendant's motion to dismiss, without properly converting the motion into a motion for summary judgment. Now, while facts subject to judicial notice may be considered in a Rule 12b-6 without converting the motion to dismiss into a motion for summary judgment, Romero misapplies this standard here. And this is why. After review of the court record, this court will see that Brown, who is the moving party, the plaintiff, initially submitted his amended complaint on January 18th, 2022. It was received by the clerk of the court showing as document lodged, electronic court filing 35. This was the first amended complaint submitted by Brown in response to an earlier motion to dismiss and was made in accordance and with pursuant to the rules 15A1B. All right, I'm not going to go into the details of that. You guys can look them up. That's the federal rules of civil procedure. However, Romero didn't properly docket the amended complaint until August 2nd, 2022. 7 months after it was properly received by the court.
Okay, we're going to stop there for a second. Not too much longer. I'm going to end it. But 7 months. And this is what they are doing, right? So we go back into what? Justice delayed is justice denied, people. You got, and he should have put that in there. I don't think he did. It's been a while since I've seen this video. But he should have put that in there. Justice delayed is justice denied.
Brown has reason to believe that the only reason that Romero finally docketed this properly submitted amended complaint was in response to his request for a decision paper filed on July the 11th, 2022. Romero states in her report that the court granted the defendant's request to take judicial notice under the Federal Rules of Evidence 201 of the state court case docket and other case-related materials. By doing this, this greatly prejudiced Brown's due process rights and prohibits him from his right to be heard in this court. The materials attached to the defendant's motion to dismiss occurred long after the filing of Brown's amended complaint, 6 months to be exact. Taking judicial notice of these facts constitutes an impossibility, unless, of course, Romero has a time machine and or can magically see into the future. So there you go.
The time machines. That's good.
Yeah. I really wanted to hit this one hard.
That's a funny one.
So,
James,
yes.
can I pause you just for a minute for
Go ahead.
those that are new to all of this? Can you just explain very briefly what's the summary judgment is and why it's important?
So a summary judgment is basically stating that there is no material issue at odds. So there's no material fact at issue between between the parties, and that one party is entitled to judgment as a matter of law. So basically what it means is that if we were to take this to trial, a jury would find that the plaintiff is entitled to judgment after all of the facts are presented before the jury.
No controversy.
Exactly. There's no controversy before the court. And so this rule allows a party to ask the court to grant them their judgment based on that same principles. Like, hey, there's no controversy before the court. But what I'm stating is that there is a controversy before the court. And the court is greatly prejudicing our rights in favor of the defendants if they adopt this report. So, I won't go on.
All right, so we're going to go ahead and stop there. You can read some more of this, go to his channel, or just let me know in the comments if you want me to kind of finish this out. At the very end, he talks about Bill of Attainder and how this is actually in conflict of our Constitution. And this right here is really a kind of form of Bill of Attainder. They're suing because of tax law, or this one may not be. I think his case is, but this one's not. But I think this was under free speech in the Senate, main building of the Utah. And since they violated his free speech. All right, this is 20 minutes long. Gee Louise. All right, anyway, if you want me to kind of do a little bit more of that, or you guys can go to his channel and check it out. Okay? Till next time. Bye, y'all.